Peace. What's going on? It's your brother MD checking in once again. MD Primetime special edition. Quick topic we want to produce. Couldn't save it for arena this week. Too much to dive into. What's up, Black Son? What's happening?
Yeah, you're right, man. I mean, man, we've been getting hot off the press stuff. Yo, how's my mic? God damn. Hold on.
Yeah, you're good.
Oh, okay. Sorry about that, man. My mic is tripping. Yeah, man, a lot of breaking news just popping out, man. So yeah, man, it's like now. It seems like now, yeah, we got to get used to these breaking newses, man, because they just popping out, man. Shit.
Right. No doubt. So, of course, for the people that haven't seen Arena Abroad yesterday, go check that out. As we were going in with Arena Abroad, of course, the ruling and the opinions came out yesterday of the Supreme Court of the United States, the decision as far as affirmative action when it's dealing with college admission. So we're going to try to dive into that tonight. And what I'm going to attempt to do, and it's going to be hard for me to do it because I know how a lot of Negroes think. But what I'm going to attempt to do is to try to provide the information and the reasoning behind these particular decisions made in this particular decision that was brought out by the Supreme Court of the United States. If we got time, I'll get into the dissenting opinions as well, because I think it's important to get into them to see what the insight is as far as what the people that voted for upholding affirmative action, see what their thought process is. But I want to mainly focus on the reasoning behind them overruling it. And as we always say over here at the arena, because we're very astute when it comes to the constitutionality of a lot of different things. But as you all know,
ruled. How the fuck you gonna overrule the Constitution, man? Keep the defendant silent.
You already know it.
So with that being said, we're gonna get straight into it. I'm gonna present my screen, and so I'm still in the truck. I ain't went home yet. My internet, I thought my internet was gonna reset today. It hasn't. So if I cut out, Black Son knows to take over the helm and
Yeah,
man the control.
Yeah, I'm all queued up.
And so again, Black Son, if I start breaking up or anything start going funky on my end, just let me know, and that's my cue to go down and come back up on my phone, and I just read off everything off your end.
Okay, tempo.
But let's bring up this first article. I'm not gonna read the article. They have a audio that I'm gonna just play out. I'm a for the sake of copyright, I'm gonna blank out the screen. We're just gonna listen to the audio, and that's gonna be a prerequisite of us getting into the actual opinion of the various Supreme Court justices in this particular matter. So let me go. This is gonna be from NPR. Damn, I should have Okay, they don't matter. Okay, so yeah, this NPR news. It says Supreme Court guts affirmative action effectively, ending race consciousness. Bump. I ain't gonna play it out. We'll just do it. Let me play it. Let me know if you can hear the audio, Black Son.
Okay, tempo.
The U.S. Supreme Court effectively ended race-conscious admissions policies at colleges and universities across the country.
Yeah, it's pretty good.
Rulings along ideological lines, the court invalidated admissions programs at Harvard and the University of North Carolina. NPR legal affairs correspondent Nina Totenberg reports.
The decision reverses decades of precedent upheld over the years by narrow Supreme Court majorities. Chief Justice John Roberts, a longtime critic of affirmative action programs, wrote the decision for the court majority. Many universities, he said, have for too long concluded wrongly that the touchstone of an individual's identity is not challenges bested, skills built, or lessons learned, but the color of their skin. Our constitutional history does not tolerate that choice.
It said our constitutional history does not tolerate that choice. Let's continue.
Noting that the court's most recent affirmative action decision in 2003 had suggested that there would have to be an end to such programs at some future point, Roberts essentially said that time has now come.
It feels tragic.
Columbia University President Lee Bollinger has for 30 years been a leading proponent of affirmative action.
It feels like the country has been on a course of choosing between a continuation of the great era of civil rights and another view of we've done this long enough and we need a whole new approach in the society. It's now the second choice.
That sentiment echoed Justice Sonia Sotomayor's dissent. The court, she said, entrenches protection by further entrenching racial inequality in education, the very foundation of our democratic government and pluralistic society.
Racial inequality came from the dissent of Justice Sotomayor.
Justice Ketanji Brown Jackson, the court's first Black female justice, chimed in, quote, "With a let-them-eat-cake obliviousness," she said, "the majority pulls the ripcord and announces color blindness for all by legal fiat. But deeming race irrelevant in law," she said, "does not make it so in life. Indeed, the reality is that in those places where affirmative action has been eliminated, there's been a severe drop in minority and particularly African American admissions." NYU law professor Melissa Murray was the acting dean at the University of California, Berkeley in 2016 and 17, when a state referendum barred the use of race in college admissions decisions.
There was an immediate drop off in the number of African American students. And that was both a confluence of the change in the admissions policy, but also African American students not wanting to go under those conditions. People want to be with other people like them. They don't want to be spotlighted. There's a kind of comfort in numbers. And it was very difficult, I think, for a very long time to recruit under those conditions.
Indeed, the situation got so bad,
So Negroes feel more comfortable if there's a vast majority of the Negroes in the college, yet we the college admission staff should be implementing race-based admissions in the college. So let's continue.
she says that she had to go to the president of the state university system to get permission to place clusters of African American students in classes instead of sprinkling them around. Now every school will
Got to have Negroes in the same class in order for them to feel comfortable. The hell with learning. Got to have the Negroes in the same class, so they will feel a sense of inclusion. Let's continue.
Now every school will be in that situation, or so it may seem. The court did not entirely close the door to racial considerations in college admissions. As Roberts put it, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life.
It's the important part.
The court specifically left open the possibility that the nation's military academies, because of their, quote, distinct interests, may be able to continue with their very successful affirmative action programs, which have resulted in a very diverse officer corps. University of California professor Jerome Karabell.
That issue is so sensitive because it raises the question of national security that the court has backed away from following its own logic.
And he notes that a similar logic might apply to police forces seeking to recruit minorities so as to ensure that a virtually all-white force would not be policing a majority Black town. For the vast majority of colleges and universities in the country, however, diversity will no longer be an acceptable rationale for taking race into account. The decision likely will cause ripples in every aspect of the nation's economic, educational, and social life, from the Rooney Rule that requires a minority applicant to be considered in all NFL coach hiring decisions, to employment and promotion decisions, DEI programs in schools and workplaces, and much, much more. Harvard Law professor Randall Kennedy.
We're going to be fighting about this for the next 30 years.
Professor Kennedy points to what he calls double talk in the Supreme Court's majority decision. Take two signs, he says. One says Black people stay out, and contrast it with a sign that says Black people welcome.
Both have race in them. Are they truly both racially discriminatory? Well, the Supreme Court, at least in one side of its mouth, seems to suggest that, yeah, they're both racially discriminatory. But then at the end of his opinion, it says, well, of course, one can look favorably upon somebody who has overcome racial impediments.
Indeed, today's Supreme Court decision, plus dissents and concurrences, reached a book-sized 237 pages. Race has never been an easy subject for Americans to deal with, and it's about to get a lot harder. Nina Totenberg, NPR News, Washington.
Well,
Okay.
there you have it. Oh, shit.
Right.
Go
There
ahead.
you have it. So we're dealing with the Supreme Court decision. So a lot of the skeptics are saying that you're going to have a drastic drop in the admissions in a lot of different educational institutions as a result. Now, here's where an argument comes into play. So the average person will say, "Oh well, this particular Supreme Court decision was based on UNC and Harvard." Well, Negro, it's called a precedent. When precedents are set, the precedent is set based on a particular case. This particular case being Harvard, UNC. It's in effect for all college admissions, and also it sets precedent for future admissions in other institutions. Just like the lady said at the end of the article, the Rooney Rule with the NFL, where you got to interview a certain amount of Black NFL coaches, the police force, any governmental institution, basically. Also, any armed forces institution, West Point, Annapolis, all your armed forces, your officer institution. This can take effect pretty much anywhere. Now, they want to open the door in saying that you could still, in a way, create a loophole in terms of the admission of Black people by basing it off of certain merits and certain actions of things that a certain person has overcome based on their race.
Right.
You know what I'm saying? I ain't got no problem with that. For that's just like me saying I'm a dean of a college, and I'm looking at the admission letter of a young Black person that's overcome certain disparities in his neighborhood in order to get to the point where he's at, where he can now submit an admission letter to my college. But that's not based ultimately on his race. That's still based on his merit at the end of the day.
Right. The merit. Right.
So the racial part is just what he overcame.
Now, I was always under the impression, even since I was a little kid, that it was about like, okay, a white person and a Black person having the same merit. And if it come down to it, the affirmative action would choose the Black person. That's what I was led to believe coming up. So you're saying that's not the case, or?
Well, that should have been the case.
Okay, that's okay. That was what you're saying. Is that the original? Oh, go ahead. I'm sorry.
No. I'm saying, yeah, you're correct.
Okay, so that was the original concept, or
right
in the 80s. I'm gonna say the 80s because like I said, I was born.
Yeah, you would be correct, but
Okay.
the criteria changed. Also, the demographic changed. So the criteria based on the merit of the person, if a certain value of a black person was equal to the certain value of a white person, for the sake of diversity, it could have been possible, for the sake of diversity now, that that particular black person would be picked over that particular white person.
Right. That was always my concept growing up, but of course, yeah.
But
Okay.
you're right. But it was always for the sake of diversity, though.
Right.
That's the negative, in my opinion. You see what I'm saying?
Okay.
Like it for so let's say we talking about Harvard, and it's only a couple Negroes going to Harvard. For the sake of diversity, even though I totally agree that this particular black person has the credentials
Right.
to be admitted to that institution, for the sake of diversity, it seems as though that stuff goes out the window and is giving you a plus. Some people look at now the way my mindset is now, if we're talking about taking away a spot for the sake of diversity, that's my issue. The merit in itself defeats all.
Right.
If he's qualified to go there, he's qualified to go there.
Right.
Period. You see what I'm saying?
Yeah.
But,
and affirmative action shouldn't affect that, right? I'm just
you would in a realist society, you wouldn't think it would.
Okay.
You wouldn't think it would be a need for affirmative action based off of that.
So I'm okay.
You see what I'm saying? But in any event, I understand that essentially it was a lottery. Essentially, think of it this way: if you got a certain amount of Negroes, that, and we'll keep using the example of Harvard. You got a certain amount of Negroes that's all trying to get into Harvard. They all submit letters. They all pretty much have the same equal amount of credentials to be able to obtain admission to Harvard.
Right.
Then it becomes a lottery, just for a specific group of people. It ain't no lottery for no white man.
Right.
Because they simply going off the merit of the white man. Period. Whereas with the black folks, it's only a certain amount that's being that are being able to qualify to get this admission based on affirmative action. Once they got their field of Negroes, that's it. You see what I'm saying?
Right.
So that's why I disagree with affirmative action. Now, with all that being said, let's get into the opinions of SCOTUS and see what they say. And this is where we're finna get down in the dirt. So let me share my screen. This is where we're finna get down in the dirt. Because again, I don't disagree with affirmative action. I disagree with how it was implemented.
Yeah.
And also the evolution of how affirmative action started to go after you got mass immigration in the country. Because once mass immigration came into effect with many different ethnic groups, Black Americans got drowned out. But hell, we all know that. But let's get into it.
All right.
Let's get into it. Share my screen again. Let me know when you can see my screen.
All right, blow it up a little bit. That's good.
Good.
You go one more. Go 175. Boom. Okay, that's perfect. That's perfect.
Okay, all right. So this is the official opinion document of the Supreme Court. And the official title is Students for Fair Admissions Incorporated versus President and Fellows of Harvard College. So that's the court case that this is setting the precedent for. Harvard College and University of North Carolina are two of the oldest institutions, blah, blah, blah. So that's who we're dealing with in this particular court case. Now, I want to get down to, I'm going to have to use my phone for a reference. So give me 1 second.
Okay, Tempo.
Damn phone for a reference because I can't do the same stuff I could do on my phone on my damn. What page is that? 61. So let me go down to page 61. I hope this shit is right on my phone like it is on the computer, but we'll find out in a minute. Okay, 60. Okay, so this is Justice Thomas in his opinion, right? Let me see if I can find it. So I'll start reading from here. The most commonly held view today, consistent with the rationale repeatedly invoked during the congressional debates, is that the amendment was designed to remove any doubt regarding Congress's authority to enact the Civil Rights Act of 1866. That's what you're talking about, the 13th, 14th Amendment.
Right.
The Civil Rights Act of 1866, and to establish a non-discrimination rule that could not be repealed by future Congresses. Reconstructing the Privileges or Immunities Clause, noting that the primary purpose of the 14th Amendment was to mandate certain rules for racial equity, especially those contained in Section 1 of the Civil Rights Act of 1866. The amendment's phrasing supports this view, and there does not appear to have been any argument to the contrary predating Brown. You're talking about Brown v. Board Education. Consistent with the Civil Rights Act of 1866's aim, the amendment definitively overruled. He talking about Chief Justice Taney with Dred Scott decision. Overruled Chief Justice Taney's opinion in Dred Scott that blacks were not regarded as portion of the people or citizens of the government. So with that being said, right now he's talking about how the Civil Rights Act of 1866 overruled the Dred Scott decision. I remember this was a couple of weeks ago when I was talking to Yangi. He was either over here or I was on his channel. He said that the Dred Scott decision was not overruled. This says the Civil Rights Act of 1866 definitively overruled the Dred Scott decision. But who was the Dred Scott decision for? That blacks were not regarded as portion of the people of or citizens of the government and had no rights which the white man was bound to respect. And like the 1866 Act, the amendment also clarified that American citizenship conferred rights not just against the federal government, but also the government of the citizen states or president. He's just giving a backdrop here. Unlike the Civil Rights Act, however, the amendment employed a wholly race-neutral text. Remember that word, race-neutral. Extending privileges or immunities to all citizens, even if its practical effect was to provide all citizens with the same privileges then enjoyed by whites. The citizenship guarantee was often linked with a concept of equality. Combining the citizenship guarantee with the privileges or immunities clause and the equal protection clause. We talked about that a couple of weeks ago. The 14th Amendment ensures protection for all equal citizens of the nation without regard to race. So a preconceived notion about the 14th Amendment was it was just for black folks. That's the reason it was put in there. No, it wasn't. The prerequisite was to protect the rights of black folks after emancipation. Yeah, I totally agree. But the amendment itself is not written that way. The amendment itself is written to be in regards to all people that's citizens in the United States. Every piece of legislature in the Constitution written like that. It's nothing in the Constitution that specifies any group of people, period. Period. So certain things happen as a prerequisite for the ratification of the amendment, but the amendment itself ain't got nothing to do with the group. Let's continue. Put succinctly, our Constitution is colorblind. Now, I don't agree with that word, but he used in the period closely following the 14th Amendment's ratification, Congress passed several statutes designed to enforce its terms, eliminating government-based black codes. The black codes you talk about that the white folks use, systems of government-imposed segregation, and criminalizing racially motivated violence, lynching, so forth and so on. The marquee legislation was the Civil Rights Act of 1875, and the justifications offered by proponents of that measure are further evidence of the colorblind view of the 14th Amendment. The Civil Rights Act of 1875 sought to counteract the systems of racial segregation that had arisen in the wake of the Reconstruction era. Look how they're going back to solidify everything. You don't have a choice but to go back to Reconstruction, because at that point where we were made full-blooded citizens of the United States of America. Advocates of so-called separate but equal systems, which allow segregated facilities for blacks and whites, had argued that laws permitted or requiring such segregation treated members of both races precisely alike. Blacks could not attend a white school, but symmetrically, whites could not attend a black school, arguing that in light of the social circumstances at the time, racial segregation did not necessarily imply the inferiority of either race to the other. That's how they tried to justify Jim Crow. Congress was not persuaded. Supporters of the soon-to-be 1875 Act successfully countered that symmetrical restrictions did not constitute equality, and they did so on colorblind terms. Free government demands. All right, let me. Okay, this was he getting down to Charles something. Let me get down here, and they submitted that the time has come when all distinctions that grew out of slavery ought to disappear. As long as you have distinctions and discriminations between white and black in the enjoyment of legal rights and privileges, you will have discontent, parties divided between black and white. Leading Republican Senator Charles Sumner compellingly argued that any rule excluding a man on account of his color is an indignity, an insult, and a wrong. That's the radical Republican Charles Sumner that said that. I insist that by the law of the land, all persons without distinction of color shall be equal before the law. Far from conceding that segregation would be perceived as inoffensive if race roles were reversed, he declared that this is the plain oppression which you would feel keenly were it directed against you or your child. He went on to paraphrase the English common law rule to which he subscribed, makes no discrimination on account. Okay, so again, all they're doing right here is giving a prerequisite as to certain distinctions when it comes to how law was written after the emancipation of the slaves, the freedmen, right? So let's get into something else. Let me go to my other part that I had here. And then this is a long ass document. It's like 250 pages. So y'all got to give me a minute. Black Son, can you still hear me?
Yeah.
Okay, all right, I'm still good.
Yeah, it still sounds good. Yep.
Go to the other part I had. I got it highlighted. I just got to sift through the pages. Give me a second. What you finna say something?
No. You sound good. MD, you there?
Yeah, you hear me?
Oh, yeah. Okay.
Yeah, hold on. Give me a... Damn, where's that other part? Thank you, right here. And like I said, we ain't gonna be long. I just want to point out a couple of things. Just want to point out a couple of things. Before I get down to to Gursuch and his opinion. This might be everyone. So, all right, let me see if I can start here. Okay, this Chief Justice Thomas again. It says the Reconstruction Amendments had aimed to remove the race line from our systems of government. For Justice Harlan, the Constitution was colorblind and categorically rejected laws designed to protect a dominant race, a superior class of citizens, while imposing a badge of servitude on others. History has vindicated Judge Harlan's view, and this court recently acknowledged that Plessy should have been overruled immediately. Talking about Plessy versus Ferguson, should have been overruled immediately because it betrayed our commitment to equality before the law. As a matter of fact, one of the justices in Plessy versus Ferguson quit the Supreme Court at that time in the 1800s because he knew it was some bullshit. He knew it was some bullshit, and he knew it was unconstitutional. So he quit. Because it betrayed our commitment to equality before the law. Dawes versus Down. Nonetheless, and despite Justice Harlan's efforts, the era of state-sanctioned segregation persisted for more than half a century. They still getting into racial discrimination of that time. Despite the extensive evidence favoring the colorblind view, as detailed above, it appears increasingly in vogue to embrace an anti-subordination view of the 14th Amendment, that the amendment forbids only laws that hurt but not help blacks. Such a theory lacks any basis in the original meaning of the 14th Amendment. Now he finna go in. Respondents cite a smattering of federal and state statutes passed during the years surrounding the ratification of the 14th Amendment. And Justice Sotomayor, talking about Justice Sotomayor's dissent, argues that several of these statutes evidence the ratifiers' understanding that the Equal Protection Clause permits consideration of race to achieve its goal. Upon examination, however, it is clear that these statutes are fully consistent with the colorblind view. Start with the 1865 Freedmen's Bureau Act. Now check this out. The act established the Freedmen's Bureau to issue provisions, clothing, and fuel needful for the immediate and temporary shelter and supply of destitute and suffering refugees and freedmen and their wives and children, and the setting apart for the use of loyal refugees and freedmen, abandoned, confiscated, or purchased lands, and assigning to every male citizen, whether refugee or free, not more than 40 acres of such land. The 1866 Freedmen's Bureau Act then expanded upon the prior year's law, meaning the 1866 Freedmen's Bureau Act was the expansion of 40 acres and a mule. 40 acres and a mule started off as Special Field Order 15. It was only a particular area. Everybody know the story when Sherman marched through Georgia, that particular area down in South Georgia and a little bit of South Carolina. That was only 40 acres and a mule. The Freedmen's Bureau Act expanded it to all freedmen. Give me 1 second, Black. So I gotta look for my damn shit for my shit cut off. Hold on.
All right,
damn chart. It's
the
tough.
charge. Okay, the charge. Okay.
Yeah. Okay, I got it.
All right.
So just pay attention. He using this. He using the Freedmen's Bureau for a reason. He ain't have to bring that up, but he did. Let's go. The 1866 Freedmen's Bureau Act then expanded upon the prior year's law, authorizing the Bureau to care for all loyal refugees and freedmen. Importantly, however, the acts applied to free. They how you say it, Black Son? How you say damn the certain font? Shit. When they do the font a certain way, italicized. I think that's how you say it. You see how the font is different where it say Freedman.
Yeah. How it's like, how it's kind of slanted.
Yeah, I forget what they call that shit. It's italicized, I think.
Okay.
The acts applied to that means they put an emphasis on it.
Right.
The act applies to freedmen and they put refugees in parentheses because you did have refugees, a formerly race-neutral category. So hold up, wait a minute. Let me read that again because I don't think, I just think it just went over the Negro's head. Importantly, however, the acts applied to freedmen and refugees, a formerly race-neutral category. So wait a minute, Negro. I'm saying I'm a freak, right?
Right.
I'm saying anybody that comes from the formerly enslaved, now emancipated, are freedmen, right? But Clarence Thomas just said that's a race-neutral term. So can I get something done by being black, or can I get something done by being freedman based on the Constitution? Because the Constitution says you can't do nothing based on somebody's race. But you can do something based on somebody's status. Freedman is a status. Let's continue. A formerly race-neutral category, not blacks, right large. He's saying, so look, acts applied to the freedmen, a formerly race-neutral category. That don't mean all niggas. That's what he's saying in layman's terms. And because not all blacks in the United States were former slaves, freedmen was a decidedly under-inclusive proxy for race. I'll be damned. Moreover, the Freedmen's Bureau served newly freed slaves alongside white refugees. We know those white refugees were the people that got plundered during the Civil War. They was also entitled to certain services under the Freedmen's Bureau Act. I ain't got no problem with that. Marino, racial class. Oh, I ain't reading that. The original meaning of the 14th Amendment and advocates of the law explicitly disclaim any view rooted in modern conceptions of anti-subordination. To the contrary, they explicitly clarify that the equality sought by the law was not one in which all men shall be 6 feet high. Rather, it strove to ensure that freedmen enjoy equal rights before the law. Not niggas, not black folk, freedmen, such that each man shall have the right to pursue his own way, life, liberty, and happiness. Period. So they telling you, hey, look, we can't go by affirmative action because they basing affirmative action off of race. That ain't our fault that y'all read it that y'all you know what I'm saying? Y'all did it that way. What I'm saying is come back to the table with an actual status. That's why it's so important for us as black folks to claim the status. That status is not going to support all black folks. It's not. I'm sorry. Us as freedmen, us as the some people will say native black. I don't like using that because that's a misnomer for niggas being Indians, and I ain't going for that. You know what I'm saying? But what I'm saying, the formerly enslaved, newly emancipated, and their descendants have a particular status in this country. Until we can get back to that status, you ain't gonna get nothing done. Period. Not if you keep basing it off of black, where everybody can leech off of your preconceived status, because that black ain't no status. It just ain't. Freedmen's a status though, just like veterans are status, just like Indian freedmen is a status. I remember I was on with Nyame one day. And I think you remember that, Black Son. And Nyame was saying there's no freedmen in the United States. I was like, huh? He was like, the freedmen were the emancipated slaves. That's it. I proved time and time again through precedent that the actual legal term for freedmen was newly emancipated former slaves and their descendants, to say it plain as day. And also, how do I know that? Because I see an example of the Indian freedmen. They weren't enslaved people, but they still use to this day, even to the point where they got it on their tribe card. You don't hear them calling each other black.
Right, but you
At
never
all.
had the opportunity to present that to Yami, did you? Because I remember that
I
conversation.
did at the end, but I think he had left when I
He
was
had
pulling
left,
it
of
up.
course.
Yeah,
Y'all
he
was
had
doing a
left when I was
drive-by.
pulling it up.
Okay.
Yeah. But in any event, like I hope he got the point. You know what I'm saying?
Nah, he just did a drive-by.
Because you can make that same argument for the Indian freedom. You can make the same argument. Why are they calling themselves freedom right now? Because that's their status. They can't get nothing done under no race, especially not with no native tribes.
Right.
You know what I'm saying? But in any event, so I think that's the part I wanted to pull right there. I got another part I want to pull with Justice Gursuch. Let me see. And he's still talking about freedom. I ain't even, you know what I'm saying? I just wanted to pull that particular article. He's saying another law passed in 1867 provided funds for freedmen in the District of Columbia. However, when a prior version of this law targeted only blacks, oh shit, I didn't even know this. Hold on.
Uh-oh.
It said, let me go back. Another law passed in 1867 provided funds for freedmen or destitute colored people in the District of Columbia. This was March 16th, 1867. However, when a prior version of this law targeted only blacks, was criticized for being racially discriminatory. Discriminatory. It was defended on the ground that they were various places in the city where former slaves lived in densely populated shantytowns. Congress thus may have enacted the measure not because of race, but rather to address a special problem in shantytown. Okay, so he's saying that they didn't base it off of race, they based it off the condition, which is also smart. But they still, at the end of the day, you're still talking about freedom. These laws, even if targeting race as such, likely were also constitutionally permissible examples of government action. So this is going into the point where they was talking about in the actual article about you might be able to give special considerations for race under like government, like armed forces and shit like that. You know what I'm saying? But that ain't even the part I wanted to get into. I wanted to get into Kurt Gersh's part. Discuss. He's still talking about the Freedmen's Bureau. I ain't even know that. Damn, he took pages. All six at the same price. Okay, all right. I ain't gonna get to it. But I'll be here all night. Get it to Gersh's opinion. Or Gersh's. $237 pages. So that's in the Sotomayor dissent. I don't want to see none of that. Or Gersh's. That's Brown things. All right, let me go. Go right here. Give me a second, y'all. I'm trying to find Gersh's opinion, man. This thing long, man. This thing long as hell. While I'm on my phone, man, so I can hurry up and flip. You know what I'm saying? Scroll down. You can't do that on the computer, man. Going through all them pages. Take this shit right here. Take this shit right here. Some of that stuff highlighted. Come on, man. Don't put me like that. All right, let me go to page 126. All right, so this Justice Gursuch, part of his opinion. You talk about Title VI and the Equal Protection Clause and all this stuff. It said, put differently, they read Title VI to prohibit recipients of federal funds from doing whatever the Equal Protection Clause prohibits states from doing. Justice Powell and Justice Brennan then proceeded to evaluate racial preferences in higher education directly under the Equal Protection Clause. From there, however, their paths diverged. Justice Powell thought some racial preferences might be permissible, but that the admissions program at issue violated the promise of equal protection. Justice Brennan would have given a wider berth to racial preferences and allowed the challenge program to proceed. Justice Stevens, also writing for himself and three others, took an altogether different approach. Now they talking about the prior ruling on what how you could use like Title VI in the Equal Protection Clause under the 14th Amendment and how to work around that when it comes to like admission. It began by noting the court's settled practice of avoiding the decision of a constitutional issue if a case can be fairly decided on a statutory ground. He then turned to the broad prohibition of Title VI and summarized his views this way. The university excluded Baki from participation in its program of medical education because of his race. And now the court case is the Baki case. The university also acknowledged that it was and still is receiving federal financial assistance. The plain language of the statute therefore requires finding a Title VI violation. So what they're saying is any school that was receiving like federal funding, which most schools do, unless it's like a true private school, you know what I mean? Like what's a private college, like Sean? Is the Ivy League, all the Ivy Leagues are private, right? I think. Oh, Black Son, Jet. Damn, am I still on? Damn, I don't even know if I'm still on or not. Damn, my shit went out. Black Son, you hear me? Hey, somebody give me a one in the chat if they can hear me. Oh, shit. Y'all give me a second, y'all. Let me make sure I'm still live.
MD, you good? My mic was muted. You good?
Oh, okay. All right. Yeah.
Yeah. I was muted.
Yeah, man, I'm on eggshells, man. Because, like I said, bro, at any point in time, my internet gonna go out. Like it's pretty much. Oh, okay, you said you're like okay.
Oh, there's Inyame. We just there. Go Inyame.
Oh, peace, Inyame. What's up? Yeah. Like I said, at any point in time, my internet gonna go out. I pretty much already know it. So.
Okay.
It'll be a miracle if it don't.
My bad. Let me send a thing for Inyame to come on.
The link in there. It's in there.
Oh shit! I didn't even see that. Okay. Inyame, you jump on anytime if you feel like it. If you got time, brother. Okay.
All right. Let me finish.
I mute my mic.
All right, cool. Damn, I forgot where I was at. He then turned to the broad prohibition of Title VI and summarized his view this way: the excluded Baki from the university also acknowledges that it was and still is receiving federal financial assistance. The plain language of the statute. Oh, I remember what I was saying. So basically they're saying that any school that was receiving federal funding, which pretty much is all of the state college and university systems in the country, except for like your Ivy Leagues and some of your other private colleges, all receive federal funding in some type of way through the state. So they're saying like based off of that, it was perceived discriminatory through affirmative action or the I guess you would say the disassociation of affirmative action. Let me get back into it. In the years following Bakke, the court hewed to Justice Powell and Justice Brennan's shared premise that the Title VI and the Equal Protection Clause mean the same thing. They reference in other court cases. Justice Stevens' statute-focused approach receded from view. As a result, for over 4 decades, every case about racial preferences in school admissions under Title VI has turned into a case about the meaning of the 14th Amendment. And what a confused body of constitutional law followed. So Gursuch's about to go in. For years, this court has said that the Equal Protection Clause requires any consideration of race to satisfy strict scrutiny. Remember, we talked about what strict scrutiny is. Strict scrutiny is basically when they put or they throw a red flag on a particular case. Race is going to throw the red flag, strict scrutiny, meaning it must be narrowly tailored to further compelling governmental interests. Outside the context of higher education, our precedents have identified only 2 interests that meet this demanding standard. Remediating specific identified instances for past discrimination that violated the Constitution or a statute, and avoiding imminent and serious risks of human safety in prison. Within higher education, however, an entirely distinct set of rules emerged. Following Bakke, this court declared that judges may simply defer to a school's assertion that diversity is essential. So they just left it up to the school and its educational mission. Not all schools, though, elementary and secondary schools apparently do not qualify for this deference. Okay, that's what I wanted to get to right there. Let me see what the other place on purchase say. Damn, I wonder if I can do it right here. Phone update. Okay, I'll start right here. If Bakke led to errors in interpreting the Equal Protection Clause, his first mistake was to take us there. These cases arise under Title VI, and that statute is more than a simple paraphrasing of the Equal Protection Clause. Title VI has independent force with language and emphasis in addition to that found in the Constitution. The law deserves our respect, and its terms provides us with all the direction we need. Put the 2 provisions side by side. Title VI says no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjugated to discrimination. That's it. That's Title VI in the Equal Protection Clause, right? Under any program or activity receiving federal financial assistance, the Equal Protection Clause reads, no state shall deny to any person within its jurisdiction the equal protection of the law. That such differently worded provisions should mean the same thing and plausible on its face. Consider just some of the obvious differences. The Equal Protection Clause operates on states. It does not purport to regulate the conduct of private parties. By contrast, Title VI applies to recipients of federal funds, covering not just many state actors, but many private actors too. In this way, Title VI reaches entities and organizations that the Equal Protection Clause does not. So basically, like in that Bakke case, he tried to do the 3-card money. He was like, well, look, this say this. Nah, Negro, you know what I'm saying? You can't do that. And like you said, like they were saying in the forward opinion, that that particular case, I think it was when did they say that was in that article? 20 something. But that was a prerequisite to ultimately what was going to happen today. Well, yesterday. But that ain't all. I got one more thing I wanted to go with Gursuch, and that'll be pretty much it. Gotta find it. Hold on, give me a second. Yeah, let's go here. Let's go here, page 133. We talk about strict scrutiny. As a result, the court has long held that racial classifications by the government, including race-based affirmative action programs, are subject to strict judicial scrutiny. Under strict scrutiny, racial classifications are constitutionally prohibited unless they are narrowly tailored to further a compelling governmental interest. Narrow tailoring requires courts to examine, among other things, whether a racial classification is necessary. In other words, whether race-neutral alternatives could adequately achieve the governmental interest. That's going back to what we were talking about with the armed forces. Importantly, even if a racial classification is otherwise narrowly tailored to further a compelling governmental interest, a deviation from the norm of equal treatment of all racial and ethnic groups must be a temporary matter, or stated otherwise, must be limited in time. 1978, 5 members support race in higher education did not violate the protection of law. Okay, they're going back into 78. The block here. Okay, they giving all the particular opinions of that court case with them just at that time. Is that particular place with Gursuch, man? What the hell? Trip. Okay, that's Kavanaugh. I don't want Kavanaugh. Okay, this whole thing because so I'm out of okay. I'm into Kavanaugh joint now. Let me say ATC4. I might just say bump it. I can't find that particular spot I wanted with Gorsuch because he hit a home run on something that he said. Damn, I know I should have took a screenshot of it, man. But yeah, he talked about the strict scrutiny though. That's what I wanted to get into with him because we talked about strict scrutiny a couple of weeks ago and what that means as far as trying to get something done and how particular matters of race, religion, or sex is always going to enter strict scrutiny. Always. I mean, ain't no getting around it. You know what I'm saying? I want to try. Let me try to find one more thing real quick. Hold on. One more thing, and then I'm done. Be done. Why is it doing me like this, man? What the hell? Trip. Okay, here you go, right here. 112. Let me go. I believe it's it. All right, so let me start right here. Now, and after this part, I'm gonna be done. It says, despite, and this is Gorsuch still, despite that warning, others eventually used this classification system for that very purpose, to sort out winners and losers in a process that by the end of the century would grant preferences in jobs and university admission. These classifications rest on incoherent stereotypes. Take the Asian category. It sweeps into one pile East Asians, Chinese, Korean, Japanese, and South Asian, Indian, Pakistani, Bangladeshi. Even though together they constitute about 60% of the world's population. Bernstein, okay, that's this what is that? Agglomeration of so many people say pays our countless differences in language, culture, and historical preference. It does so even though few would suggest that all such persons share similar backgrounds and similar ideas and experiences. Consider as well the development of a separate category for Native Hawaiian or other Pacific Islanders. It seems federal officials disaggregated these groups from the Asian category only in the 1990s and only in response to political lobbying. And even the category contains its curiosities. It appears, for example, that Filipino Americans remain classified as Asian rather than other Pacific Islanders. The remaining classifications depend just as much on irrational stereotypes. The Hispanic category covers those ancestral language in Spanish, Basque or Catalan. But it also covers individuals of Mayan, Mixtec, and Zapotec descent who do not speak any of those languages and whose ancestry is not traced to the Iberian Peninsula, but bears deep ties to the Americas. The white category sweeps in anyone from Europe, Asia, west of India, and North Africa. Check this out. Inyame, shout out to Inyame. That includes those of Welsh, Norwegian, Greek, Italian, Moroccan, Lebanese, Turkish, or Iranian descent. It embraces an Iraqi or Ukrainian refugee as much as a member of the British royal family. Meanwhile, Black or African American covers everyone from a descendant of an enslaved person who grew up poor in the rural South to a first generation child of wealthy Nigerian immigrants, to a Black identifying applicant with multiracial ancestry, whose family lives in a typical American suburb. If anything, attempts to divide us all up into a handful of groups have become only more incoherent with time. American families have become increasingly multicultural, a fact that has led to unseemly disputes about whether someone is really a member of a certain racial or ethnic group. There are decisions denying Hispanic status to someone of Italian, Argentine descent. That they got a court precedent for that, as well as someone with one Mexican grandparent. They got a court precedent for that. Yet there are also decisions granting Hispanic status to a Sephardic Jew whose ancestors fled Spain centuries ago. They got a court case for that. And bestowing a sort of Hispanic status on a person with one Cuban grandparent. They got a court case for that. Given all this, is it any surprise that members of certain groups sometimes try to conceal their race or ethnicity? Now he's talking about other ethnic groups doing the three-card money to use affirmative action, or that a cottage industry has sprung up to help college applicants do so. He talking about how the Mexicans and the Koreans used our 10-piece lemon pepper with fries money to go to Emory. We are told, for example, that one effect of lumping so many people of so many desperate backgrounds into the Asian category is that many colleges consider Asians to be overrepresented in their admission pools. That's the part I had wanted to get into. He going to it a little bit more deeper, but he talking about like inclusion and diversity and all that type of stuff. So what I'm saying is, when we look at what affirmative action was based off of, I think they missed the mark with a lot of different aspects of things that were there to help the free. When I say, and like I said, I don't want to confuse nobody. When I say freedmen, I'm talking about help Black people that were directly affected by the institutions here in America from the onset. From the onset, not not the black people that were able to benefit from the sacrifices, from the work that we put in from a legal standpoint in order to benefit all people that had the ability to be naturalized in this country. And I think that's where we missed the mark at. When it comes to certain policies that we put forth that are specifically for us, we need to make sure that they're specifically for us.
Right.
How do we do that? You can't do that with black. I'm sorry, you can't. You can't do it. You can't do it for a specific group of people, because when you do that, it creates the wormhole that was affirmative action. Because that's exactly what it was, a wormhole. It sucked up every other minority except for your black ass. Period. You had some that seep through and use it as a launching pad to then denounce it. You know what I'm saying?
Right.
And look at it from a different perspective. Like I said, I can only try to attack it in a position where hypothetically I'm a person that benefited from affirmative action. I can only do it that. So if I'm a black person that benefited from affirmative action, how do I then look at affirmative action? You know what I'm saying? I benefited from it. It was for me. So do I champion it? Do I gatekeep it? Or do I denounce it based off the constitutionality? So I think a couple of Negroes in a conundrum. If I ain't mistaken, I gotta look it up. Matter of fact, let me look it up now. Yeah, I want to see if Clarence Thomas went to school off of affirmative action.
Oh, damn. You know, I used to hear that back in the day, but I don't know how accurate that is. But I know they used to always make that joke. But I know Inyami would know offhand, but I don't know if he was I think he was, but I don't know how accurate that is.
Okay, it says and then hell, this of course it's CNN, of course.
Okay.
They say Thomas, one of the court's most conservative members, has long been known for his distaste for affirmative action policies.
Right.
He has been open about the fact that he made it to Yale because of affirmative action. So yeah, he did.
Yeah, okay. I thought that was true. Okay.
But says the stigma of preferential treatment made it difficult for him to find a job after college. How difficult it is now, Negro. You a damn Supreme Court justice.
Right.
So yeah, so that's how you gotta look at affirmative action. Like I can, because I didn't go to college, so I can't, you know what I'm saying? But how can I view it in the eyes of a Negro that benefited from it? You know, learn the law because of it, and then ultimately denounce the shit. You know what I'm saying? Now from me learning the stuff that I learned, I can understand where it has its downfalls in terms of how it's worded. Like I said, I ain't got no issue with affirmative action. I got an issue with the way it was perceived from the colleges and universities and from the corporate world and everywhere else it was used. You know
Well, would you say that it metamorphed into something else? What it was?
It did because of the word. Because of the word. You know what I'm saying?
Okay. So because it metamorphosed, you're saying that it needs to be done away with because the original purpose of what it was for, it just didn't work. So
it got watered down.
Can you reform it though?
Well, to reform would it be reformed or will it just be rewritten?
Oh, that's a tough one. I guess it would have to be rewritten to specify for the times of today. You know what I'm saying? Because I'm sure you have to make a lot of adjustments, especially the whole Freeman thing, because now you got more larger populations of Jamaicans, Nigerians, Ethiopians, and all that, so forth and so on. And even you got people from the Pacific Islands that
every minority.
Yeah, every minority, right? Yeah, Pacific.
You know what I'm saying?
Yeah. So yeah,
white women. But
So
no,
then let me ask you, so it was written for the Freemans, and
no,
then
no.
it was
It was written for a specific group of people. It wasn't written in the language of a specific group of people. Does that make sense? Remember,
it
we
wasn't meant, so you're saying it wasn't written specifically for the Freemans. Is that what you? I mean, I'm trying to.
no, because they didn't use that language. They
Oh,
remember.
there you go.
We
Okay, there you go. There you go.
we dealing.
So it would have to be rewritten for the Freemans
It will have to be.
in order
Again.
Well, I mean, I'm assuming it was supposed to be for the Freemans, but in order to now correct it, it would have to be totally rewritten.
Peace,
No,
y'all.
Hey, and
Yami, what's up, man?
What's up? What's up? I just wanted to. Hey, did y'all know Clarence Thomas was a Black Panther when he was a teen?
Yeah. He
Oh,
got away
yeah.
from it.
Yeah, he got away from it. But I wanted to say affirmative action wasn't necessarily for Black people. It was for people who was at a disadvantage, like women, or discriminated against in the past. So it wasn't necessarily for Black people.
Okay.
All right, so this one. So let me do this real quick.
So then, Inyami, based on what MD was reading, so you're saying that it's actually serving its original purpose, correct?
Yeah, that's what I'm saying. It's serving its original purpose. Even though in the beginning stages, we had the most benefits. Like for myself, when I got into the IBW, this was the 90s, the mid 90s, early 90s.
Okay.
The generation before me, they got in because of affirmative action. Even in the late 70s, early 80s, they wasn't letting Black people in those trade unions.
Right.
A very select few, but affirmative action kind of forced that door open.
Okay.
Right. For diversity's sake.
For diversity, yeah.
Yeah, I get that. But what I'm saying is the force behind the act itself was Black folk. Period.
Oh, of course. And so they do what they always do. They make us compromise. Oh, we're not going to do nothing just for y'all.
Right.
It's got to be for everybody. If we give y'all anything, it has to be for everybody. They've never addressed us specifically. Everything we do has always been for everybody. That's the way this government has operated.
Well, I will argue, and y'all made that they do that because they legally can't. You know what I'm saying?
See, this is the problem I have. They created the problem. They created race. We didn't. And now all of a sudden, they want to be so rigorous with the Constitution. Oh, we can't do nothing with race. But y'all created the problem. Fix the problem, and then we can be this harmonious nation. But you got to fix the problem that you created. So I'm saying, if MD, if you went out and you purposely picked out left-handed people, and you was the government, and you said left-handed people can't get a job, and then left-handed people take you to court, and the court say, well, that was MD. MD did that, but MD was a government official. He acted on behalf of the government, fixed the problem first, and then we can remedy it for everybody. And to me, they're trying to scapegoat it to where they don't want to remedy the past problems that this government has done to Black people.
I agree with that to a certain extent. Where if a certain entity or a certain group or a certain legislature do something to a specific group, it should be remedied. But you still can't take away from the prerequisite, which is the Constitution. The Constitution is written in a certain way. Now that ain't me saying that it's end all be all and it ain't loopholes, and we know it's loopholes. That's how you got Plessy versus Ferguson. I get it. You know what I'm saying?
Right.
But what I'm saying is, when you're talking about remedying something and making something right, set forth, you have to base it on something, and the base is the Constitution. If the so let's go back to affirmative action. Affirmative action was written a certain way because you legally can't do something for a specific group of people, but you can do something for a status. We see it all the time. We just got finished talking about the Indian Child Welfare Act, the Veteran Affairs Act. All these different things is based off of status. Why is it such a hard pressing move to consider a particular black group in the country a status? Is that taken away from our blackness? No, I don't believe it is.
No. But you know what I'm gonna say it is. You know what I'm gonna say it is.
Go ahead, say it.
It's white supremacy.
Oh.
To me, it's that simple. It's not rocket science. You know, you already admitted. I mean, this government has already admitted that they broke their own constitution. They broke their laws. They violated their laws by one, giving us this racial category, and then making us second and third class citizens behind it when we're citizens. Basically, we are citizens, and we was discriminated against because of our lineage. That's unconstitutional. They know who we are. It's not going to take rocket scientists to find people who trace back to those times and remedy that problem. But we got to cross every T. We got to dot every I. We got to be so perfect just for them to hear us in court. Come on.
So you said something very important. I mean, you said lineage.
Right.
Can I consider my lineage to be a status?
Yes.
Okay, then we agree then. Because that's what a freedman is. You basing it off your lineage.
But freedmen are black people, right?
They are, but not all black people are free.
I understand that, and not all white people are Germans.
There you go. So we talk about a distinct ethnic group then. At the end of the day.
Yes, but we're talking about a distinct group of Americans.
No doubt.
That's the thing. That's why I don't know why it's so hard. If it was 20 million white people that had been discriminated against that long, they wouldn't go through the rigor that we going through. Right. To say, because they've already admitted that they violated it was a violation. I'm not even talking about slavery. I'm talking about 1866 onward. You know what you did. You've already, because of 1964, 1965 Civil Rights Acts, you admitted that you had violated Americans' civil liberties. All they have to do is identify those Americans that did it, and justice be served. Why do we have to go through so much rigor to prove that point? And I know what they're doing. We're going to have to do it as individuals. I'm going to have to take myself and my family and prove specifically where did the government violate my family's civil rights. That's what they want.
I mean, you could do that right now.
Right,
and now I agree to a certain extent with that. Individually, we have to, because our lineage is tied to us as individuals. It ain't tied to the group.
Right.
It's tied to us as individuals. That's why.
And that's what they want. That's what they want.
I don't necessarily disagree with that, though. What I'm telling you, Yame. If we base it off of lineage, just like I base my veteran status off my individual commitment to the country in the armed forces at that particular time, from such and such to such and such. I served Air Force, Army, Navy, whatever. Your lineage is directly tied to you individually. It's a group of people, don't get it twisted, but the lineage is tied to you, nobody else. Your freedman status as a status in itself is tied to you individually, nobody else. So I agree from the sake of that perspective that it should be done individually. Now, every case from a legislative standpoint is not going to be done individually. That's when we're going to have to link up and do the class action thing. At some point in time, it's going to have to be a political movement tied to everybody's individual lineage, because that's what freedmen is. You can't do that with black. You just can't do it.
But
and that's
when we're going to run into circles. So we're going to get together, bring this class action lawsuit.
Well, I just use that. I ain't saying that it's got to be. I'm saying we could do it in other political matters. I just use class action lawsuit because that's how I tie it all together. It don't necessarily have to be that, but politically, it can be done collectively from the group, tying our own individual lineages together. That's what I'm saying.
Right, but man, why it has to be that difficult?
As a matter of fact, I would say it should have been done a long time ago.
Yeah.
But we didn't link it that way. We linked it to blackness. That's what I'm telling you. We the ones that linked it to the race.
But I still don't see why, like when Callie House, Callie House, when she brought it forth, what did the court say? It statute of limitation. They gave her that fraudulent judgment. You know what I'm talking about?
Yeah, I concede to that. And matter of fact, Callie House was presenting specific claims to land that certain black families had. So I concede to that. But like I said, we look what time we. You know what I'm saying? I totally get it.
Yeah. So I'm just saying it started to look like you're playing games. I'm gonna tell you, one time I went to the it's called Sewage and Water Board of New Orleans for a supervisor position, and everybody said, "Man, you got the experience. Go get it." And it opened up because of affirmative action. They had to give it to a black person, because I mean, for years and years, even though New Orleans is dominated, the dominant people of New Orleans was black, every supervisor in this position was white. So I go in there and they give me a test, and I take the test, and I wanted to know what I made on the test, and they told me, "Oh no, I can't tell you what you made." I said, "I don't want to know if I got the questions right. I just want to know what I made so I can have an understanding." And he wouldn't tell me, so I knew it was a game. I knew he was playing the game. Then the next day, they called me and said, "No, I didn't pass." So I knew that it was a game he was playing, just so they can say no black person can fulfill his role. They don't have the education, and it went to somebody white. And so, to me, what the court is doing, they're making it difficult for us to ever, as a group, and I'm going to use class action lawsuit, as a group to get reparative justice from this government, because they're making it so difficult. You kind of see where I'm equating it to?
I do. Like I said, I totally agree to a certain aspect. Again, when we dealing with the legality of it, we dealing with certain language, and the issue, I'm gonna continue to say, is the language. Whether you agree with it or not, the language in itself has been wrong for decades, literally decades. So it's been stagnant based off us perceiving what we have to do is do it through a race-based strategy. Cannot do it through a race-based strategy. Time and time again, what, Black Son? This is like the third decision that we done went through this year already. That's affirming that nothing can be done on race. And what I'm telling you is, even if I'm telling, hey, let's just give it the old college try. If it don't work, it don't work. Then I'm Black Power all day. The fact of the matter is, it hasn't been tried. If we go through with the stat, matter of fact, we got a clear-cut example with the Indian freedmen. The Indian freedmen putting in work every day, getting resolutions done, and they not basing it off being Black. Period. They just not. They base it off being free. They giving us the blueprint. They saying, hey, American cousin, here's what we did. Do the trial. The Supreme Court agrees with what we doing. Y'all should try it too. And we ain't doing it. That's what I'm saying.
Yeah,
same exact situation.
I don't have any problem with that. At least give it a shot. I wouldn't kick back against it.
And it's a lot of people that are. There's a lot of people that are. That and it won't take away from your Blackness in any shape or form.
No, it doesn't take away. But
that's all I'm saying.
But I will even sit, in the back of the room and let y'all handle it. But the minute the judgment is over, I'm going to speak, because for them to say the court would not make a judgment based upon race, and we got 250 years of this government making decisions based upon race, that's a lot of violations. That's a whole heap of violations. And
I get it.
Yeah.
You ain't gonna get no argument from me about that. All I'm saying is, when it comes to the discrimination in and of itself, even when you're dealing with the discrimination, you still can't get away from the fact that discrimination was dealing with a particular group of people. We're talking about slavery at the end of the day. We're talking about the effects after slavery to a specific group of people. Now, when things start to be alleviated toward certain policies that were given out, that were a force behind the work that we was doing, of course, because of how the language was written in a particular policy, it's going to give leeway and loopholes for other minority groups, quote unquote, to base that equality off the gatekeeping that we do. You know what I'm saying? What I'm saying is, let's get out of the gatekeeping. Let's focus more on the delineation of who we are as a group in the country. Once we can do that, I think we'll be okay. Black Son, you still there? What the hell, Black Son be doing? But yeah, like I said, man, we agree on most stuff that we saying, y'all, man. But I like I said again, this particular example, other examples that happened this year, has shown that whatever we try to do is not going to happen based off of race. It just ain't. It's been like that for ages now. Even with the particular civil rights acts that were put in place based off our plight, they still wrote it in a certain way where it's going to include all people. When you get certain aspects of a status-based claim, then that's when you can start to single out who's who and what's what. So that's what I was trying to bring out here tonight.
Right. I know you're talking legalese, and I'm talking more the social aspect, because we wouldn't be in this predicament if it wasn't for this government classifying us as Negro or Black. They base that on our African genealogy. Like, even if, like, the one drop rule is just ridiculous. You might have just had a grandmother who was Black, and they say you was Black, because they so hated that African gene.
Right.
And they based everything off of that. They started the problem. And it's like, okay, you started the problem. You benefit from that problem. And then you force us to jump through hoops to try to get this problem solved. And you know what this government has done. That's all I'm saying. Not as a legal person. I'm not on the legal team. I'm just talking about as a human being. But we know who created this problem. We didn't do it. We didn't come here as we were dark skinned, dark people, but we came in here different nations of people.
Right. Yeah, that's a fact. That's a fact. Like, yeah, we came here different nations of people, and we got classified at that particular time as black because of the superiority complex that the white people had at that particular time. I mean, hell, go all the way back to the inception of the country where they started the classification under Bacon's Rebellion. I totally get it, but when the ratification started to go down, those same people. Well, I ain't gonna say them same people. Let me not say it. But that same government also gave us a different classification. That was free. Then you can't get around that. You know what I'm saying? So the same way we can use that classification as black to specify the disparity, we can use the government classification as freedmen to alleviate that pressure legally, because ain't nowhere in the Constitution where it say you can't do that. You know what I'm saying? So yeah, that's what we had. But you said, man, I'm trying to pull this up, man. My damn shit running slow. You were saying something about they based it off of our African descent.
Yeah,
it was actually a Supreme Court case. Yeah, it probably ain't gonna pull up though, because my internet shot. I'm still in my truck. It probably ain't gonna put. Hey, Black Son. Black Son. I don't know where he at, man. I guess I ain't gonna be tripping, man. But yeah, it's all good though, Black Son. Damn, is it gonna pull up? Yeah, it's still low. Yeah, I'm still in my truck, man. So my Wi-Fi gone. Hey, Black Son, we finna get ready to get out, man. If you're still there. But yeah, I appreciate it, Yame, though, man. We go but yeah, we definitely gonna discuss this, man. I can't wait for season 6. I can't wait.
Yeah, it's gonna be good. Yeah, because to me, I think I don't know, but it seems like people are saying everything was based because we were slaves, and it was based because of our African lineage.
I agree, but see, man, see, we can go deeper than shit. We can go way deeper than that. Because, like I said, I'm not the one to say that it's 100% entirely based off the African lineage, because we know that the colonizer was dealing with African people from a trade aspect. So if it was solely based on our African descent, how did they how did they distinctly categorize African people in totality if they were dealing with them in trade?
I don't know what you mean by that.
Well, what I mean is, so I'm assuming that you mean when they categorized us as black and gave us a certain classification in regards to when we got here in America. Why was that same disparagement not instituted in Africa during colonization when they were dealing with African tribes in trade?
I'm saying that it was.
Oh yeah, you're gonna have to clarify that one, because when I say African trade, I mean not only in goods, but us too. They was trading us.
No, I agree with that.
So that mean it had to be some level of I guess you would say dissemination between the blacks that they were trading with and the blacks that they were subjugating. It had to be.
I think the only difference was that the blacks that they was trading with, they couldn't colonize or they couldn't capture at the time, and the other ones they could, because eventually they was able to colonize the entire continent. I don't think they saw any different. They just saw an opportunity to utilize us as chattel. And the people they could, they used, and the people they couldn't, they didn't, until they got the power to use them too.
Yeah, I see what you're saying, but still, you can't get away from that. It was levels to it. You know what I'm saying? Even if you want to say that they were essentially using them particular groups of people, you could say that. That's fine. But it's still there. You know what I'm saying?
Yeah, still, and there's levels in the Americas too. There was levels.
It was levels of subjugation. Yeah, out nigga and feel me. Yeah, I get that.
Right. Okay, you would have, sometimes we forget the free nigga, house nigga, field nigga.
Yeah. You're right. Well, yeah, man. Like I said, man, we gonna definitely we gonna get into that. Like I said, I can't wait for it.
Yeah.
I got so much stuff for you. Good God. Hey, Black Son. Hey, we about to get ready to get out. I don't know where you at, man, but I'll close it out. But,
okay. All right. Peace. Good talking to you.
All right. Peace in y'all, man. Shout out to y'all, man. Like I said, I can always count on a good conversation with y'all, man.
Oh yeah.
So I know he ain't gonna come here and babble me. And y'all man ain't gonna babble you to death, man. And y'all ain't gonna keep it real. He gonna yell. Shout out to y'all. Yeah, but we gonna get on up out of here, man. Good combo. Damn, that's fine folks in here. Y'all be tripping with that.
Yeah, man. Hey, y'all man, don't be a stranger, man. Don't be doing drive-bys, man. Hey, y'all, man.
Yeah. I've been just real busy, man. Real busy. I'm trying to get things together before season 6 come in. It's gonna come quick.
Okay.
Yeah. I was trying to get you Black Son. All right. Shout out to y'all, man. Peace, y'all, man.
Peace.
Yeah, I'm sorry. Trying to get
you it's all good. Don't worry about it. I was gonna get you to pull back up this the opinion thing. Don't worry about it now, though. Don't worry about it now. It's 10 o'clock. So but it's all good, man. Like I said again, dealing with this particular ruling on affirmative action, we have to understand. It's not me being against affirmative action. It's me being against the way the language of affirmative action, and not just affirmative action, but a lot of policies that they try to perceive to be race-based in the guise of equality. All of it. I don't give a damn what it is. You know what I'm saying?
Right.
In the terms of trying to alleviate some type of harm based off of race-based strategy, it's not going to cut it. I keep saying it time and time again.
Institutional, right.
And you not dealing with it from a legality standpoint is not taken away from your blackness. It ain't. I know I'm black at the end of the day, but I'm black culturally. I'm not black scientifically, or I'm not black historically. I'm black culturally.
Right.
Based on.
And even though, and Yama made a good point that they violated the Constitution, we can't re-violate the Constitution in order to match their wrongdoing, But
what I tell you, low-level collective thought fighting low-level collective thought.
Right,
I never denied what white folks did legislatively
Well,
in the
that's
past.
what I should have asked Yami. Like, does he expect us to break the Constitution in order to, I guess, that old saying, fight fire with fire. Like, do we stoop to the level and violate the Constitution and then reverse that? Or I guess they used to call that back in the 80s reverse racism. So I don't know. But damn, you know what? And Yami, man, I hope you come back, man, because we could definitely chop it up on that. But yeah,
we can have another show on it, man. Like I said, it's an interesting topic.
It is.
It's an interesting topic, man. And like I said, when you're dealing with like Yami said, the legalese, how does one operate through that? You know what I'm saying? As a black person,
basically what you're saying though. But I mean, yeah, I guess he's saying, and now the government's saying, yeah, you know, we violated the, you know, constitutional rights and so forth and so on. So my question would be like, okay, well, so do we resolve it abiding by the Constitution and, like I said, rewriting the and see, that's why I'm saying, because like a lot of people, I think what they see, MD, is that okay, our civil rights and our constitutional rights were violated, so then therefore we need to, and I guess that's where reparations comes in. But it's like when you use the example, when you have one government official that is not abiding by the Constitution, and then that person passes on, or that person, you know, like how do you well, I guess you rectify it with reparations. But so yeah, that's where, yeah, I'm just, you know, I'm trying to.
Well, so what Nyame was saying was, why do we have to put the work in to identify the harm done? That's just like saying you at work and your white coworker come up to you and y'all on lunch or whatever, and he take your damn food out the refrigerator and call you a nigga. If that happened, what you gonna do, Black John? Your ass, you gonna sue. You're not gonna sue him. You're gonna sue the company,
right?
Off of discrimination of the company. Just like if another truck hits your truck, you're not gonna sue him. You're gonna sue who? The company that he worked for.
Mm-hmm.
If a woman at work and a dude come and slap on the ass, she's not gonna sue him. She gonna sue the company,
right, for
sexual harassment. So I'm not treat reparations the same way. A harm was done to us. I'm not suing the white man. I'm suing the United States government because the harm was done through the United States government. They're not gonna say the man who slapped the woman on the ass ain't gonna say I'm sorry and then pay her.
So I mean, I guess to cut through the chase. So would you say, and I know because you always lead it back to reparations. With the reparations, then we wouldn't need affirmative action, correct? Am I safe to say that, or
why would we need affirmative action? For what? For what?
We wouldn't need it.
What I'm telling you is reparations through. I'll give it. Let's say we got reparations today.
Okay.
I would give it 2 generations. After 2 generations, if we had reparations today, after 2 generations, not only would we be on par with quote unquote white supremacy, we would be a rocket ship ahead.
That sounds funny. On par with white supremacy. I'm just wow.
I threw up the air quotes, man. I threw up the air quotes.
I know. I mean, it's just hard for me to conceptualize on par with white supremacy, but
it don't sound right, do it?
It don't even not when you live in Georgia.
So, but what I mean to say is, not only will we be on par with let's just say the status quo of what we perceive the American middle class to be.
But the status quo is not the top 1%.
That's the whole thing. I don't give a shit about the top 1%. I don't know how anybody could perceive.
I perceive the status quo as a working class. That's just me, though. But
that's why I said the middle class.
Okay, so okay.
But the perception of the middle class is not black, even though me and you know that a vast percentage of black people are middle class in the eyes of the economic status quo. You see what I'm saying? Hell, nowadays the economic status quo of the working class pole too. You know what I'm saying? But I'm talking about the idealistic.
Right, because most people they strive to be that 1%. That is the ultimate dream, to be that 1%.
I think people that strive to be the 1% are stupid. I'm gonna keep it real. 1%.
Well, when you talk about when people talk about white supremacy, they're thinking about 1%. They're not thinking about the status quo. The status quo, the majority of
I agree with that.
Right. I mean, that's a fact. The majority of white people are below. Or let's just say, you know what? I'm gonna just say working class. I'm gonna just put that, just keep it within the safe zone. But I mean, you got a small percentage, 1% of black people, white people, Asian people that are 1%. You know what I'm saying? That 1% is a 1%. And so the rest of the people, if you say status quo, people, if you bring them up to that level, they're not looking at the stat. They're looking at the damn 1% level. Most people, but like you said they would be stupid. So it's like I'm gonna jump out the window and say that most black people that scream racism, white supremacy, and woe is me and boo hoo hoo, they want to be that 1%.
So, but that's confusing though, because if they're looking at the 1% as racism, white supremacy, where does that leave the 99% of the other white people? What are they?
Somehow they missing that. Again. It's just like, people in Georgia, they missed one of the largest three of the largest trailer parks are all white people right off Moreland Avenue. But hey, white supremacy, racism, the white man. But and majority black people are judges, police officers, lawyers in Atlanta, Metro Atlanta. But hey, white supremacy, leave a white man. But
right. Well, again, we talking about the opportunity. We talking about like Milton Friedman said, the equality of opportunity, not the equality of outcome.
Okay.
So if I'm looking at the equality of opportunity, I got the right to take the chance in order to achieve being that 1%.
Well, oh man, I forgot to ask Yami if he could join us on one of those, man, because I definitely want to get his. I mean, I kind of know where he's going to go, but I definitely want to engage him in a conversation with economics. That's really what I want to engage Yami on some economics, man, because at the end of the day, intelligent brother at the end of the day, but I don't never hear an end game. I don't never hear what this other economic system look like. I mean, we can make an assumption, but I want to hear him say it though. I want to hear him say it.
Well, we'll get into it one of these days, man. Like I said,
I know.
Yeah, we got ample enough time. But yeah, man, let me go and get up out of here, man. I got to get up tomorrow so I can ride.
Man, good show, man. Yeah, and be safe out there. I know you still got a couple of 100 miles to go. So man, be safe.
Yeah. It's gonna be an all-day drive tomorrow, but it's all good. It's all good. Mm-hmm. So again, the plan is to do Kachian tomorrow. We'll see how that go. I ain't gonna set it in stone just yet.
Well, just like I said, just make it to Georgia, and just see how you're feeling, man. You know what I'm saying? Just make it to Georgia, because like I said, you still got like a ways to go. So yeah, just let me know how you feel when you make it to Georgia. You know what I'm saying? Not before Georgia, not South Carolina, not Virginia, not North Georgia, and let me know how you feel.
I got you, man. I got you. Matter of fact, I was riding through, and this is another quick story, and I'm gonna get off. So I was riding through Appomattox. You know, Appomattox where the Civil War ended. They had a sign out there that said Appomattox, the place where the Union reunited. I was like, huh? I was like, last I checked, they didn't reunite. The fucking Confederacy conceded. They lost. So I just thought that was funny. That's lost cause all day.
Oh,
You know what
101.
I'm saying?
Yeah, lost cause 101. Hey,
Lost
yeah.
cause all fucking day. The place where the Union reunited. That's it. They got it all throughout the damn. Like as soon as you enter the city limits, that's where I'm like, no, they was in Appomattox because they gave up.
Right.
Like, ain't no damn reunite. They conceded to war. But in any event, I just found that one fun. But yeah, man, we finna get up out of here, man.
All right.
We
So
finna
yeah,
get up
like I
out
said,
of here.
call me when you get in Georgia. Let me know how you feeling. Like I said, you could be all energized. Soon you hit the Georgia, boom, that it's just sometimes it's a psychological thing. But yeah, just let me know how you feeling.
Yeah. Like I said, usually the nighttime is like as long as I get home, I'm looking to get home like around 4 or 5, something like that.
Right, but
And
remember you got that driving fatigue though too.
that shit. I usually have driving fatigue early. Like I be tired when I drive. Usually at nighttime I'll be all right. For some odd reason, I don't know.
Okay.
Like I'll be tired as hell. Like I'll drive all day. And usually I don't drive all day because you know what I'm saying? Like I'm short haul. So,
Right.
but on the times I drive like all day, I'll be tired as shit. And then I'll get home. I don't go to sleep.
Yeah.
I don't go, you know what I'm saying?
Okay.
But we'll see how it goes, man. We'll see how it goes.
All right. Sounds good.
Especially like as soon as you get in the house, kids asking you for shit and all that. Yeah, you can't go to sleep. You know
Yep.
That as soon as you get in the house, they want you to take them somewhere. I'm like, damn, I just got in the house. Like, what the hell? Like, what's going on?
Mm-hmm.
So hell, usually I can't go to sleep. But yeah, man, we'll figure it out. Like I said, I'll let everybody know what's up with it tomorrow. If we don't do it tomorrow, we'll definitely do it on Sunday. Like we'll definitely do it.
Well,
Shout out to Nate.
Go ahead. Oh, go ahead. No, go ahead.
I was gonna say shout out to Nature Mom. Hopefully I'll be in the building for that show too on Sunday morning.
Absolutely, yeah. Real quick, MD. I don't know if you deal with the High Museum.
Yeah, the High Museum of Art. Yeah, it's been a while since I've been there, but yeah.
Okay, so starting July 23rd to February 4th, they're gonna have the samurai exhibit. I don't know if you would like to take your sons to that. I'm gonna take my sons.
Oh, okay,
Yeah.
cool.
You got Bank of America?
No.
Oh, okay. Sometimes they'll let you in for free if you got an account. You just show your bank card and they let you in for free.
What type of shit is that?
The perks, benefits programs.
Okay. Yeah. Okay.
Yeah, part of the I mean, you pay for it in the long run. Your banking account, but yeah, they try to draw customers. But yeah, Chase and they all got like their little perks and shit. Like Chase do like concerts and shit, but Bank of America in the High Museum, they have some thing going where you still got to pay for parking, but yeah, they will give you free admission. Oh, well, general admission. So yeah,
Man, it's been a while since I've been to the High, man. Like it's been
me too. But I've been seeing on the buses them advertising damn samurai suits. I was like, oh shoot, I gotta go see that, bro. You know what I'm saying? Now, me and my son, we were joking because I don't know the authenticity of those suits, but we're gonna, I guess, go pretend like, even if I just want to go see him, bro. I just want to go see him. So yeah, we're gonna head over there.
If it's at the High, chances are they artistic pieces.
They're authentic?
No, artistic.
Oh, okay, replicas.
Yeah, because the High is not like a historical museum. It's just an art museum.
Oh, okay, gotcha. Okay, so okay. That's what we.
If I had to assume they rep.
Okay, because that's what my son was asking me. He's like, Dad, man, he's like, those are replicas. I said, well, son, it's just, let's just go. You know what I'm saying? I mean, I get it, but yeah, he's one of them types, man. Is it real? I'm like, I get it, but yeah. So,
Yeah.
but it still would be nice to see.
Yeah, a couple years ago, I took my kids to they like going to the Carlos damn, what's the name? The one over there at Fern Bank.
Oh yeah. I forgot the
Damn,
damn
what's the
name.
name?
Yeah, I love Fern.
Carlos something. That's the Egyptology. That's what I call it because that's all they got in there, motherfuckers. Egypt shit.
Oh, okay. I'm thinking about the one with the dinosaurs. That's the Fern Bank. I'm sorry. I'm thinking about something else.
Fern Bank got dinosaurs too. I call it the Egyptology Museum because that's what they specialize in is Egypt.
Oh, that's right. They got that little section. I forgot about that. Yeah.
Michael C. Carlos Museum. That's it.
That's right. You know, when I go in there, I go straight to the dinosaurs. That's why. Okay, you're right. They do have Egypt stuff in there, but yeah, I'm a dinosaur man.
Yeah.
You know, yeah. Show me dinosaurs in Egypt, I'm gonna go straight to the dinosaurs. So yeah, it just
Yeah,
All right.
that's one of the top paleontology
Yeah.
museums in the country. Yeah, so yeah, they got it up in there for you. You know
Oh,
what I mean?
absolutely. Yeah. I
You
enjoy
know that's Emory. So Emory don't play no game. You know.
They play no games, not at all. They don't play any games at all.
All right, man.
Okay.
Now what you say?
No, that's how I like the botanical gardens too. But yeah, that's just
Yeah.
And Callaway, I like that shit too. I like that kind of shit. I'm in the nature big time.
All right, man. Well, yeah, we're gonna get up out of here.
Okay, cool deal, man.
Let me stop playing. Hey, shout out for everybody coming through, man. Hit the like button on your way out.
Yeah, man. Shout out to Yami, man. Shout out to Yami.
Yeah. Shout out to Nyame, man. Like I said, when I talk to Nyame, I can get something out of it.
Oh, absolutely. Every time. That's why I love when he comes on, man, because he don't bullshit around, man. He don't bullshit.
Nyame ain't with the nigga battle.
No, he don't nigga.
You may disagree with what he's saying, but he ain't gonna nigga about it.
He's definitely going to articulate whatever you disagree with. He's going to articulate it, man. You're going to be like, damn, but yeah. He ain't going to nigga babble you. That's for sure.
See, yeah, I can deal with Nyame because Nyame can disseminate between the different political languages. That'll be something we'll get into on another show.
Right.
Check out the audiobook series. That's going to be another one. And it's a quick book that it ain't going to take nothing but at the most 2 days to do. So before we get into Turner Diary, I'm still doing Turner Diary.
Okay.
Before we get into Turner Diaries, I'm gonna knock that one out.
Yes.
So yeah, with that being said, man, I guess that's it for tonight. We'll see y'all hopefully tomorrow with Kachi. And with that, y'all, I guess we're gonna say peace.
Peace, y'all.